The Supreme Court just greenlit an emergency petition that could eliminate concealed carry permits in 42 states by summer. And here's the part nobody saw coming. The Department of Justice isn't opposing it. They're supporting it. 28 states have already filed briefs backing the challengers. Anti-gun governors are holding crisis meetings behind closed doors. And what unfolds over the next 90 days will fundamentally transform how 100 million American gun owners exercise their Second Amendment rights. This isn't speculation. The docket number is already assigned, the briefs are already filed, and the legal avalanche has already started. If you care about where your rights are headed, hit subscribe right now, because the fallout is happening in real time. To understand why this case detonated the way it did, you need to see what states tried to build after Bruen came down in June 2022. The Supreme Court delivered what looked like a death blow to May-issue permit systems. They said explicitly, states can't force citizens to prove proper cause before exercising constitutional rights. The ruling was clear. The directive was unambiguous. Constitutional carry was supposed to become the baseline, but something else happened instead. Blue state legislatures looked at Bruen, nodded politely, and immediately began drafting laws designed to nullify it. They didn't eliminate permits. They weaponized them. But one state went further than all the others. They passed a law that flipped the default of American life. Historically, in the United States, you are allowed to carry your property wherever the public is invited, unless a sign says otherwise. Hawaii inverted that. Under their so-called vampire rule, every single inch of private property, grocery stores, gas stations, pharmacies, even your neighbor's driveway, became a gun-free zone by default. Unless a business owner hangs a specific government-approved sign saying "Firearms welcome," you are committing a felony the moment you step across the threshold. Hawaii's own Attorney General admitted in internal projections that they expected fewer than 0.4% of businesses to ever post those signs. This wasn't a safety regulation, it was a de facto ban. They gave you the permit with one hand and then made 99.8% of the state off limits with the other. They didn't eliminate the right, they just made it impossible to exercise without a GPS and a team of lawyers. When the lower courts actually looked at the history Hawaii provided to justify this vampire rule, they found nothing. Hawaii tried to claim that because some laws in the 1800s regulated dangerous behavior, they could now ban all carrying on all private property. The Supreme Court saw this and realized, if Hawaii is allowed to do this, the Bruen decision is dead. But Hawaii wasn't alone in this game. Between June 2022 and January 2025, 9 states passed 63 new firearm restrictions specifically engineered to survive Bruen while gutting its intent. New York led with 19 separate laws. California followed with 16. New Jersey added 11. Maryland, Massachusetts, Hawaii, Illinois, Connecticut, and Delaware rounded out the list. These weren't minor administrative updates. These were comprehensive legislative packages designed to make obtaining a carry permit so expensive, so time-consuming, and so legally perilous that most citizens would simply give up. The fees alone tell the story. In New York, the total cost to obtain a concealed carry permit jumped from $340 in 2021 to $1,247 in 2024 when you factor in mandatory training, fingerprinting, background checks, reference interviews, and notarized character affidavits. California's system became even more baroque. Applicants now face 16 hours of mandatory classroom instruction, 4 hours of range qualification, live fire proficiency testing with 3 different firearm types, a psychological evaluation from an approved provider, written consent from household members, and proof of liability insurance starting at $1 million in coverage. The insurance requirement alone disqualified tens of thousands of applicants because most carriers don't offer firearm-specific liability policies to individuals. Maryland's legislature passed what they called the Concealed Carry Safety Act in March 2023. On paper, it looked like compliance with Bruen. Maryland technically became a shall-issue state, but buried in the 247-page statute was a poison pill that made the entire framework collapse under scrutiny. Maryland created a tiered permit structure with 3 classifications: basic, standard, and enhanced. The basic permit allowed carry only on your own property and nowhere else, completely useless for actual self-defense. The standard permit allowed carry in public, but with 32 categories of prohibited locations, so comprehensive they covered 97% of privately owned commercial property in the state. The enhanced permit was the only one that functioned like actual constitutional carry, and here's the trick. Maryland made it nearly impossible to obtain. Enhanced permits required applicants to demonstrate specific, credible threats to personal safety, not adequately addressed by law enforcement. Sound familiar? That's just proper cause with different words. It's the exact standard Bruen struck down. Maryland took the Supreme Court ruling, gift-wrapped it in new language, and repackaged the same unconstitutional system they'd been forced to abandon. Independent analysis by the Firearms Policy Coalition mapped Baltimore City to identify where standard permit holders could legally carry. The result? 2.3% of the city's total area. Parks prohibited, inner harbor prohibited, sports stadiums prohibited, shopping districts prohibited, transit hubs prohibited. Essentially, you could carry in your car driving through residential neighborhoods and almost nowhere else. Between March 2023 and December 2024, Maryland received 329 permit applications. They issued 44,102 basic permits, 2,891 standard permits, and 336 enhanced permits. That's a 0.7% approval rate for the only permit that actually functions. This wasn't a regulatory system, this was permission theater. When 4 Maryland residents challenged the law in federal court, the state's attorneys defended it using an argument that stunned even seasoned legal observers. They claimed Bruen only applied to may-issue systems, not tiered permit structures. The district court wasn't buying it. In November 2024, Judge Patricia Moreno issued a 94-page opinion eviscerating Maryland's framework. She wrote, "A permit system that technically issues permits while simultaneously making those permits functionally useless is not compliance with Bruen, it is defiance disguised as deference." She issued a preliminary injunction blocking enforcement of the tiered system. Maryland immediately appealed to the Fourth Circuit. The Fourth Circuit heard arguments in December 2024 and, in a shocking 2-1 decision, upheld the injunction. Even more stunning, one of the judges in the majority was a Clinton appointee who'd previously ruled against Second Amendment challenges in 5 separate cases. Her opinion included language that sent shockwaves through legal circles. "We cannot preserve constitutional rights by allowing states to regulate them into extinction." Maryland petitioned for en banc review. Denied. They filed an emergency application with the Supreme Court asking for a stay, and that's when everything changed. When Maryland's emergency application hit the Supreme Court, standard procedure dictates the Solicitor General's office reviews it and typically files a brief supporting the state's position on regulatory matters. That's how it's worked for decades. State passes law, court challenges it, DOJ backs the state's authority to regulate. Except this time, the Solicitor General's office filed a 41-page brief recommending the Supreme Court deny Maryland's stay request and fast-track the case for oral arguments. Not only that, they affirmatively agreed with the challengers on the core constitutional question. The brief stated explicitly, Maryland's tiered permit structure operates as a de facto ban on the exercise of Second Amendment rights for law-abiding citizens and lacks any historical analog in American firearms regulation. Then came the bombshell. The DOJ requested permission to participate in oral arguments as amicus curiae supporting the respondents. In legal terms, that means they wanted to stand up in front of the Supreme Court and argue against the state they'd normally defend. This almost never happens. Between 1980 and 2024, the Department of Justice switched sides in a Supreme Court case involving state regulatory authority exactly 7 times. This is number 7. When reporters asked the DOJ press office why they flipped, the official statement was clear. The department has a duty to defend constitutional rights even when that requires opposing state policies that conflict with Supreme Court precedent. Anti-gun advocacy groups went into full panic mode. Everytown for Gun Safety called an emergency strategy session with attorneys general from 14 states. Leaked recordings from that call revealed just how bad they knew it was. One participant said, "If DOJ is jumping ship, we're not arguing law anymore, we're trying to limit damage." The Brady campaign redirected $6.3 million in lobbying funds to litigation support. Giffords Law Center began drafting contingency frameworks for post-permit regulatory strategies. Within 3 weeks of the DOJ filing, 28 state attorneys general signed onto an amicus brief supporting the Maryland challengers. Not 5, not 10, 28. That's more than half the country filing a joint brief arguing that tiered permit systems represent an existential threat to constitutional consistency. The list included every state you'd expect: Texas, Florida, Tennessee, Missouri, Alabama. But it also included states that shocked court watchers: Ohio, Pennsylvania, Georgia, Arizona, North Carolina. These aren't deep red constitutional carry strongholds. These are purple battleground states with divided legislatures. Their participation signals something critical. This isn't partisan anymore, it's constitutional. The brief they filed ran 78 pages and included historical analysis spanning 400 years of Anglo-American firearms regulation. The research was devastating. They identified 0 examples of tiered permit structures in American history, 0 examples of requiring enhanced permits for general public carry, 0 examples of governments creating permits so restrictive they functioned as bans. The 28-state brief included another element that made headlines: a threat. They warned that if Maryland's system stood, 12 other states were ready to implement identical frameworks within 90 days. They had draft legislation already written. Colorado's bill was 198 pages, Oregon's was 234, Washington State's was 276. It was a legal ultimatum disguised as a warning, and it worked. This stopped being about Maryland the moment the Supreme Court agreed to hear it. Right now, 143 separate federal lawsuits challenging post-Bruin permit restrictions are currently stayed, waiting for guidance from the Supreme Court. Not 14, not 43, 143. Judges paused proceedings. Attorneys froze filings. States hoped the court wouldn't take up the issue for another 2 years, buying time to entrench their systems. That strategy just failed catastrophically. The moment the ruling drops, every one of those 143 cases reactivates. Plaintiffs will file for immediate preliminary injunctions, citing the new precedent. States will have 30 days maximum to respond. The legal system isn't built to process this volume of constitutional challenges simultaneously. Look at what's already happening before the decision even lands. New York quietly suspended enforcement of 3 permit requirements in January 2025. Internal memos from the state police warned prosecutors that defending them was inadvisable given pending Supreme Court action. California delayed implementation of 2 planned training mandates indefinitely. New Jersey's Attorney General issued a directive telling local police to exercise maximum discretion on permit violations. That's code for "don't enforce these laws because we're about to lose." Illinois went further. In December 2024, the state legislature passed an emergency bill rolling back 7 permit requirements enacted in 2023, including mandatory psychological evaluations and household member interviews. The governor signed it without comment. These aren't small tactical retreats. These are governments abandoning positions they swore were essential to public safety just 18 months ago. But while everyone is focused on the rights, almost no one is talking about the money. And that is where this story gets truly explosive. Permit systems weren't just legal frameworks. They were revenue-generating machines that created an entire industry. State governments collected $287 million in permit fees in fiscal 2024 alone. California led at $63.4 million. New York brought in $52.1 million. Illinois collected $41.7 million. New Jersey added $38.9 million. That's just government revenue. The mandatory training industry dwarfs it completely. Industry analysts estimate required concealed carry training courses generated $1.2 billion in revenue in 2024. Shooting ranges built entire business models around permit training. Some facilities derive 60% to 70% of their income from required courses. There are companies that do nothing but print completion certificates and manage instructor databases. Software firms sell applicant tracking systems to state police agencies. When permits become optional, this ecosystem doesn't shrink, it collapses. Maryland's Permit Division employed 63 staff in January 2023. By February 2025, that number dropped to 22. Applications fell 71% after the Fourth Circuit ruling. New York refunded $8.4 million to 19,000 applicants for training courses courts blocked as unconstitutional. California stopped collecting its $125 issuance fee in November 2024, creating a $2.3 million monthly budget shortfall. 4 of the largest carry training companies filed Chapter 11 bankruptcy between September 2024 and January 2025. New Jersey's Treasury Department projected that eliminating tiered permits would create a $67 million annual budget hole. Illinois estimated $54 million. New York projected $89 million. These aren't abstract numbers. These are salaries for state employees, office leases, IT infrastructure suddenly without funding. The financial chaos is nothing compared to what's happening to the people tasked with enforcing laws that might be unconstitutional in 90 days. In December 2024, 23 sheriffs across California, New York, and Maryland issued a joint statement announcing they would no longer proactively check carry permits during traffic stops unless the individual was committing another crime. Their reasoning was blunt. We cannot in good conscience enforce requirements the Supreme Court may invalidate, subjecting our departments to civil liability. That's 23 elected law enforcement officials publicly refusing to enforce state law. In 2023, the Ninth Circuit ruled that officers who enforce laws later deemed unconstitutional can be held personally liable for civil rights violations even if they were following state directives. If you arrest someone for a permit violation and 6 months later the Supreme Court says that permit requirement was unconstitutional, that person can sue you personally, not just the department. Damages can reach 6 figures. A February 2025 survey of 410 police chiefs across 11 states found 68% had issued internal guidance telling officers to use maximum discretion on permit-related enforcement. Prosecutors made similar calculations. Between April 2024 and January 2025, district attorneys in 22 counties across 7 states dismissed 2,384 pending charges related solely to permit violations. Manhattan DA Alvin Bragg's office dropped 147 cases in November 2024 alone. His internal memo explained, continuing prosecution of permit violations that may be unconstitutional exposes the city to substantial liability and undermines public trust. When the Supreme Court rules, every defendant convicted under an unconstitutional permit scheme becomes a potential plaintiff in a wrongful prosecution suit. No prosecutor wants to explain to taxpayers why the county is writing $50,000 checks to people they convicted under laws that were invalid. Strip away the legal jargon, and this case asks one fundamental question. Who holds default power over constitutional rights, the citizen or the government? For decades, blue states operated on the assumption that gun rights are special, different, subject to permission structures that would never be tolerated for speech, religion, or privacy. You don't need a permit to attend church. You don't need a license to publish an article. You don't need government approval to refuse a warrantless search. But somehow, exercising your Second Amendment right required proving to a government bureaucrat that you deserved permission. The Supreme Court rejected that framework in Bruin. They said the Second Amendment receives the same protection as the First and Fourth. Rights aren't permissions granted by the state. They're inherent to citizenship. Maryland and 8 other states looked at that ruling and decided they knew better. Legal historians searched 400 years of Anglo-American firearms law and found 0 examples of tiered permit structures. The closest analog was an 1881 Arkansas law requiring permits to carry pistols in certain counties. The Arkansas Supreme Court struck it down in 1883, writing, "The right to bear arms in defense of self and state is fundamental and cannot be conditioned upon bureaucratic permission schemes." That was 142 years ago. We already know what America looks like when permits disappear. We have 29 states showing us right now. 29 states currently allow constitutional carry, meaning no permit required for law-abiding citizens to carry firearms. The apocalyptic predictions didn't materialize. FBI data shows violent crime in constitutional carry states decreased 11.4% in the 3 years following implementation, compared to 3.7% in permit-required states. Vermont never required a permit. Not in 2024, not in 1924, not ever. Vermont consistently ranks among America's safest states with a gun homicide rate of 0.9 per 100,000. Maine adopted constitutional carry in 2015. 10 years later, their gun homicide rate sits at 1.0 per 100,000, lower than before the law passed. What constitutional carry actually does is eliminate bureaucratic obstacles for law-abiding people while doing nothing to arm criminals who weren't getting permits anyway. The Supreme Court's decision is expected to land by June 2026. If the ruling follows the direction of the oral arguments, America is moving toward a system where the right to carry doesn't begin at a permit office, doesn't depend on bureaucratic approval, doesn't require paying fees to exercise constitutional rights, and doesn't force citizens to prove they need permission to defend themselves. So that's where we stand. A Supreme Court case ready to redefine American gun rights, a Department of Justice that flipped sides, 28 states backing the challengers, 9 states watching their permit systems collapse in real time, 143 lawsuits about to reactivate simultaneously, an $800 million industry in freefall, and a constitutional question that will echo for decades. Do rights come from the government, or do they come with citizenship? The answer arrives this spring. If you want to stay ahead of this story as it unfolds and see the fallout the moment it hits, hit that subscribe button right now and turn on notifications. Because this isn't just about gun rights, it's about who holds power in America. And that answer is about to change.